Okay, well, it looks like people have joined us, so I think we'll get going. Good morning, everybody, and welcome to this Co-operatives UK training webinar. For those of you who don't know me, my name's Kate Fielding. I work in the HR services team here at Co-operatives UK. I'm joined this morning by my colleague Gary Morrison, who's our senior employment lawyer, and today we're going to talk to you about conducting good investigations. We'll start off with a few slides and then we'll move on to a question and answer session at the end. So if you'd like to ask any questions, please do so by using the chat box at the bottom of your screen, and we'll get to as many of them today as we can. We're going to be recording today's webinar, so we'll send the recording out along with the slides within the next week. So please don't feel like you need to take loads of notes today if you don't want to. And also, if you've got any colleagues who were hoping to join today who haven't been able to, please do feel free to share the information with them afterwards. Hopefully we won't experience any technical issues today, but obviously we are all still at home, which I'm sure most of you are too, so please do bear with us. If we do experience any connectivity issues, please sit tight and somebody will get in touch with you. So today it's going to be a really brief introduction to conducting investigations at work. We've only got an hour, so we know that it can't be particularly in depth. We're going to talk you through what investigations are, why they're important, the things that you need to do and the things that you need to look out for whilst you're conducting them, and also some of the things that can happen if they go wrong, and some of the things to sort of be aware of, and bear in mind that certain employees may have made mistakes in the past. As we go through, you might hear us using the term employee, potentially manager. This doesn't mean that this isn't relevant to you if you're a worker co-op. All of the information that we're going to be sharing with you today is just as relevant for worker co-ops as it is for other organisations. So just before we start, I'd really like to run a quick couple of polls with you, if that's okay. The first one is just to understand a little bit more about you and the experience that you have of working in HR within your organisation. Just launch that now. Okay, that's really great. Thank you, everybody. So it's great, Gary. You can see, I don't know if you can see the results, Gary, but we've got a range of people here with different types of HR experience, which is really great to see. Thank you for doing that. I'll just launch the second one now. This is about your experience of conducting HR investigations. Sorry, I think a couple of you have had problems with seeing that poll. I'm sorry about that. The question was just around whether or not you have conduct HR as part of your role, or whether it's something that you're just interested in. This second one is around whether or not you're conducting HR investigations in the past, or whether you're new to it. And this is great, Gary. I can see that we've got a real range of experience in terms of conducting investigations here. We've got some people who do it regularly and others who are completely new to it. So that's absolutely great. Thank you, everybody, for completing that. Okay, so that's all from me. I'm going to hand you over to Gary to get started.
Morning, everyone. Yeah, we're going to look at conducting good investigations this morning. As Kate said, it's a bit of a brief trot through investigations. If we look, first of all, at the first slide, what we're asking is, what is an investigation, and why is it relevant? If we look at the dictionary definition of investigation, it's the act of investigating someone or something formal, a formal or systematic examination or research. Investigations will usually follow where either concerns have come to light relating to someone's conduct or perhaps their performance. Those concerns may, however, have come to light or being raised as part of a grievance process. We'll be looking at investigations in this webinar in the context of a possible disciplinary process, but essentially the principles are the same in terms of whether the investigation is that into a grievance that's been raised. The first slide provides you with the stages in a typical process, which, as you will see, commences with an investigation. If we move on to the second slide, we're looking at the ACAS Code of Practice. So why are we referring to the ACAS Code of Practice on a disciplinary and grievance procedures in a webinar about investigations? Well, the ACAS Code of Practice on disciplinary and grievance procedures sets out guidance on what is a fair disciplinary procedure. The code of practice isn't binding on tribunals and courts, but they will and must take into account the code when they're deciding whether a fair procedure has been followed in disciplining or dismissing someone. In addition to the code, there is a guidance which provides actually some more detailed guidance, and that runs to some 79 pages. They're both available on ACAS websites. And like I say, they're not binding on a tribunal, but a failure to follow the code by an employer is likely to result in a finding of unfair dismissal, possibly an uplift on any award. So although they're not binding, the tribunals are obliged to take this ACAS code into account. The relevance of it in terms of investigations is that what the ACAS code says it is very important to carry out necessary investigations of potential disciplinary matters without unreasonable delay to establish the facts of a case. In some cases, this will require the holding of an investigatory meeting with the employee before proceeding to any disciplinary hearing. In others, the investigatory stage will be the collation of evidence by the employer for use at any disciplinary hearing. So essentially, whilst there must be an investigation, it's not always necessary that you have to conduct an investigation hearing, but there must be an investigation. What the ACAS code also advises is that in misconduct cases, where practicable, different people should carry out the investigation and the disciplinary hearing. So unless you're in a very, very small organisation where that isn't practical, you will be struggling to show that a dismissal is fair if the same people carried out the investigation and then the disciplinary process. The only time this probably won't apply is if we're looking at perhaps performance management rather than conduct, where it may be that the employee's line manager that does the investigation, because that line manager will be familiar with the performance and the lack of performance. So that it may be the case that the same person will be carrying out the investigation and any subsequent hearing if it's related to performance, but certainly in the context of disciplinary hearings and conduct, it should be different people. So moving on to the next slide, why investigate? Well, the next slide shows some of the headlines as to what impact a badly conducted investigation can have on any future disciplinary proceedings or outcome, and perhaps any legal challenge to a dismissal. Firstly, you need to establish exactly what the reasons are for anything that might have happened or maybe why someone isn't performing. You need to determine whether there's a case to answer or not, and whether matters should progress beyond the investigation stage, either to a disciplinary hearing or to a performance management or capability procedure. In addition to ensuring that matters are dealt with fairly, if the matters perhaps result in some point in a dismissal, it will also assist you as an employer in demonstrating that you acted reasonably. If a dismissal is legally challenged in an employment tribunal, what the tribunal will require is an employer to show that the dismissal was fair, and in establishing a dismissal is fair, an employer must show that it acted reasonably. Why am I referring to the term reasonably? Well, moving on to the next slide, you will see that Section 98 of the Employment Rights Act provides where it sets out when a dismissal will be fair or unfair and what standards an employer has to meet. What Section 98 says is whether the dismissal is fair or unfair depends on whether in the circumstances, including the size and administrative resources of the employer's undertaking, the employer acted reasonably or unreasonably in treating it as a sufficient reason for dismissing the employee. What it also says is that determination will be decided in accordance with the equity and the substantial merits of the case. The legislation therefore refers to the employer acting reasonably, and in determining its reasonableness, what the tribunal will look at is also the size and administrative resources of the employer, and I'd say just the equity and the merits of the case as the employer found it and the reason for dismissing. Essentially, a tribunal will expect more of a larger employer than it would of perhaps a small worker cooperative in terms of the process that they've adopted. So the legislation talks about reasonableness, but how do you, as an employer, show this reasonableness, and why is the investigation important in showing that reasonableness? Well, if we move on to the next slide, it refers to a case of British Home Stores and Birchall. It's a 1978 case. It's a case that stood the test of time, been challenged a few times, but what it does is sets out the test an employer must meet in demonstrating that it acted reasonably in dismissing someone. And what Birchall and British Home Stores says is that it's essentially a three-step process. The employer must genuinely believe the employee to be guilty of misconduct. The employer must have reasonable grounds for believing that the employee was guilty of that misconduct. And at the time that it held that belief, the employer must have carried out as much investigation as was reasonable. In my experience, employers almost never fall down on this first point, the genuine belief. It's not difficult to show those a genuine belief, and most employers will genuinely believe that someone has done what they think they've done. However, they're much more likely to fail on the requirement to show that it had reasonable grounds for holding the belief it did. And it can only get to that point of demonstrating that it had reasonable grounds for holding that belief by showing that it conducted a reasonable investigation. It was entitled to hold that belief because it conducted a reasonable investigation. Moving on to a bit more case law, on the case of Sainsbury's and Hitt, this is a case in which the courts use in determining whether an employer has carried out a sufficient an investigation as was reasonable. What that case said is the purpose of the investigation is to establish whether there are reasonable grounds for the belief that the employer had formed that there had been misconduct on the employee's part, to which a reasonable response was a decision to dismiss. So again, we're talking about reasonableness, and was the employer reasonable in doing what it did, and was it entitled to hold that belief? The facts in this case of Sainsbury's and Hitt were that Mr. Hitt was employed. He was employed by a baker by Sainsbury's, the supermarket, from 1991. He'd got about 8 years service in, and at the time of the incident, a box of razor blades went missing or was stolen from the warehouse attached to the shop where Mr. Hitt worked. These were found in his locker. The evidence gathered indicated that Mr. Hitt had left his place of work on 2 occasions and had returned to the locker room. He, of course, denied stealing the razor blades. What he said was the box must have been planted there. And what he did was he named other employees who had keys which could have opened his locker. So there were lockers with similar keys that could have been opened. The investigation also established that the bakery manager, Mr. Hitt's line manager, was the only person on the premises at the relevant time, i.e. when the box, and we're not talking a little packet of razor blades, I think there were a box of razor blades, that the only person in the bakery was the bakery manager, Mr. Hitt's line manager, who was on the premises at the relevant time when the box of blades went missing, and was the only person who had a key to Mr. Hitt's locker. What happened was the disciplinary hearing was adjourned for a couple of weeks to allow the disciplinary manager to investigate the matter further. And what he did, that disciplinary manager looked at an investigation of locker keys, which, although he found out that other keys could open Mr. Hitt's locker, he found that no one else other than the bakery manager was in work at the time. The investigator, the disciplinary manager, spoke to the bakery manager and accepted that he'd remained in the bakery. He hadn't been into the locker room. So essentially, the only person who had another key to Mr. Hitt's locker at the time when the box went missing and was found in his locker was the bakery manager. Mr. Hitt was dismissed for a gross misconduct. He complained unfair dismissal to the employment tribunal, went to the tribunal. The employment tribunal found that the investigation was inadequate. What they said was that the employer hadn't carried out as much investigation as was reasonable before forming the belief of Mr. Hitt's guilt. What they said was that Sainsbury's should have interviewed the employee's name by Mr. Hitt. even though the investigation had established that, yes, possibly there were other people who had keys, that those people were not on the premises, the tribunal said that the employer, Sainsbury's, as part of the investigation, should have interviewed those other employees. Sainsbury's appealed to the Employment Appeal Tribunal, but the Employment Appeal Tribunal agreed with the Employment Tribunal, saying the investigation was inadequate. Sainsbury's further appealed, and the case actually went to the Court of Appeal. The Court of Appeal found that the employer had substituted its own view as to what was a reasonable investigation, instead of applying an objective standard of the reasonable employer. What they said was that the investigation was reasonable in all the circumstances. It was adequate enough to establish reasonable grounds and a belief that the employer had formed that from the circumstances there had been misconduct on the part of Mr. Hitt, to which a reasonable response was a decision to dismiss. So, whilst we would always advise that you should do as much as is reasonably possible in conducting an investigation, and certainly I think if you were going to adjourn a hearing for 2 weeks, it might be worth going and speaking to their employees. As an employee, you don't need to go beyond what is considered what a reasonable employee would do. That was the problem in HIT. Employment tribunals aren't allowed to say what they would do. What they need to do is look at what a reasonable employee would do. And what that employer, Sainsbury's, had done, had established that no one else with access to Mr. Hitt's locker was actually in work at the time that the razor blades went missing. And they said that was sufficient. They didn't need to interview the employees. The fact that they weren't there was sufficient an investigation to allow them to believe that it was Mr. Hitt who'd actually taken the blades. So if we look at the next slide, which is about the process, we'll look at some of the practicalities. What information are you looking for? Well, as someone investigating an incident or conduct, you're looking for all relevant information. An investigation is an objective information or fact-finding exercise. Important to remember that you're not trying to prove guilt. What you're trying to get is some balanced evidence from both sides on whether there's a case to answer or any basis for a matter to progress to a disciplinary hearing. A biased investigation is likely, obviously, to result in a flawed outcome and possibly an unfair outcome. In a disciplinary hearing, all evidence gathered must be considered. So you must look at it from both sides. You must gather as much evidence as possible, and that must then be provided to anyone who's called to answer an allegation in a disciplinary hearing. One of the things you may need to consider is whether suspension is necessary. So when might suspension be necessary? Well, there's a couple of grounds I would suggest that you need to take into account when deciding whether to suspend. Whether it's reasonable to believe the employee may cause damage to the business, whether there's a threat to personnel or assets, could be a physical threat to other members of staff, you need to look at their safety, whether the employee's presence may jeopardise an investigation in some way, perhaps whether evidence may be unduly influenced or destroyed. Suspension will normally be appropriate where the employee's conduct would be sufficiently serious to be considering grounds for summary dismissal. What I would say is that suspensions must always be kept under review. Perhaps if you're looking at what might be gross misconduct, or you think it may be gross misconduct when you start the investigation and it may warrant suspension, if during that investigation it becomes apparent that it's a lesser offence, then you need to consider whether that suspension is still appropriate. So you need to keep suspensions under review. Sometimes perhaps where there's a grievance investigation rather than a conduct investigation, on a bit of a theme on suspension, but not suspension, what you might want to do is consider whether it's appropriate to transfer that one of the members of staff involved in the grievance to a different area to work on a temporary basis. So if you've got an employee who perhaps raises a grievance about the line manager, perhaps an allegation of bullying, then it may not be appropriate to suspend the line manager, given the evidence and whether you've got enough, you may not have enough, but it may be appropriate to make sure the person who's raising the grievance isn't left in the same situation until that grievance is concluded. So you may want to consider whether it's appropriate to perhaps remove line management duties, or perhaps transfer the employee who's raising the grievance to another part of the business, so that the bullying that they're complaining of isn't ongoing until the investigation or perhaps the process is concluded. So who should investigate? Well, in a disciplinary hearing, it's probably going to be someone, well, it certainly should be someone who's had no involvement in the matter being investigated, and will not be required in the future to carry out any parts of a disciplinary procedure. So it should be someone who's had no involvement whatsoever, and it should be someone who is not going to be expected to carry out the disciplinary hearing or perhaps the appeal hearing if it gets to that stage. You'll recall that the ACAS Code of Practice, which I mentioned earlier, states in misconduct cases where practicable, different people should carry out the investigation and disciplinary hearing. Again, a bit of an exception to that. If it's performance or a grievance, it may well be the same person that's doing the investigation, as certainly in the case of performance hearings is doing the performance hearing. So what types of evidence are available? What types of evidence should you be looking for? Well, documentation, firstly, emails, paperwork, receipts, computer records, phone records, attendance records, policies or procedures, certainly in the case of a breach of a procedure, or where you're looking at investigation of potential breach of a policy or procedure, you need to make sure you've got that policy and can probably demonstrate that the employee who's being investigated is aware or familiar with that policy or procedure. Documentary evidence is almost always the best form. You could use CCTV. CCTV is not always conclusive, but can be helpful. You just need to be careful of using it in the appropriate circumstances. Make sure it's lawful to use CCTV and it's not being used for a reason other than which it's intended. For example, it's okay to use CCTV if you've caught somebody with the hand in the till, because the CCTV may have been installed to protect against criminal offences or theft. It's probably not okay to use that CCTV to then demonstrate that somebody's coming in late. So you can use CCTV, but you need to be careful as to what the reason is that you're recording it in the first place. Witness evidence is obviously other useful evidence. That's usually done by interviewing people and gathering and producing statements from those witnesses. So who do you need to interview if you're doing an investigation? Well, it's useful to make a list of the people you think you'll need to speak to, people who you think may be able to give evidence or may have witnessed an incident. But even if you make a list, you need to be aware that that might expand during the course of the investigation. You may need to speak to other people. Consider the most appropriate order to interview people in. It's not always appropriate to interview the employee who's under investigation first. In a simple case, that might be the way to proceed. But if it's more complex and you're relying on other people's evidence, you may wish to put questions to the employee under investigation which have arisen as a result of other witness evidence and investigation. So it's for example, on conduct cases, it's usually good practice to interview anyone raising the conduct and those who may have witnessed it before interviewing the person who is the subject of the investigation. Then you can put questions to them arising from the other evidence. It's always a good idea, I think, to ask the person who is the subject of the investigation if they think there's anyone in particular that we should interview. If there's anyone they think might have witnessed an incident, that's certainly appropriate in a grievance investigation. If they're saying that somebody's conducted themselves inappropriately towards them and they've raised a grievance, I would be asking the person raising the grievance who you think I should be speaking to as the investigator. But certainly that's appropriate as well in a conduct investigation. You know, if you think the person who's being interviewed has got any evidence or someone, they can name someone who can give some useful evidence, then ask them that in the hearing. When you're doing the investigation interview, really, you need to explore the entire issue. The witness may be, anyone you're interviewing as a witness may be able to provide more evidence than you first envisage. Certainly I would suggest if when you're doing the interviews, you can ask open questions, and it's probably preferable to ask open questions such as, explain to me exactly what you saw, describe what happened, take me through what you heard, rather than ask a closed question, which might get you a very short answer, which may not be as useful. Don't be afraid to re-interview witnesses. I've certainly done investigations where, you know, I've left it on the basis that if there's something that arises, or there's a question I've not asked, or they, you know, want to add something, that, you know, we can review it and actually conduct a further part of the interview to get more evidence. So, like I say, don't be afraid to re-interview witnesses if you think you need to. Confidentiality. An investigation should usually be kept confidential. Sometimes it becomes known, it quite often does, but even if it becomes known that an investigation is being conducted, the details of that investigation should be kept confidential. Anyone you're interviewing as a witness should be informed that it must be kept confidential, mainly to make sure that any subsequent witness evidence isn't tainted or influenced by any discussions. They should be allowed to discuss the matter with an employee representative if they've got one, but certainly if you're doing the investigation, you should be telling them that it's a confidential investigation and they mustn't speak to anyone else outside of that investigation interview about the incident. What about location? Sometimes it's relevant, sometimes it's not, but, you know, I think it's certainly worth thinking about. Think about the location of the interview and when you're going to conduct it, where you're going to conduct it. Should take place in a private room where interruptions are unlikely to occur. Usually meetings will be at the employee's normal place of work and during working hours, but if more confidentiality is required, it may be better to hold the meeting away from the workplace. I've certainly experienced a couple of claims over the years where there's been examples at both ends of the spectrum. I've had one where the employee was saying, essentially, sort of suggesting that they've been held against their will, a sort of false imprisonment. And actually what the employer had done, because the meeting room wasn't particularly private, they'd put sort of black paper over the windows and over the door, where it created the wrong impression for the employee under the investigation. Another one was where it was in one of these offices that was surrounded by glass, and the employees complained that it wasn't confidential enough. So you do need to look at the location and where you're doing it and make sure that that's appropriate. Looking at the right to be accompanied at an investigation, the Employment Relations Act 99 provides a statutory right to be accompanied at a disciplinary or grievance hearing by either a work colleague or a trade union. There is no statutory right to be accompanied at an investigation hearing. Whether a worker has a right to be accompanied at an investigation will depend on the circumstances. It's probably good practice to allow an employee to be accompanied, I would say, to offer support, but there is no statutory right. There might be a right if your or the employee's procedures specifically allow the right to be accompanied. The other things you need to consider in terms of whether somebody should be accompanied is whether the employee has got a disability. Certainly a lot of case law saying it's a reasonable adjustment to allow somebody perhaps with a mental health impairment to be accompanied at a disciplinary hearing, so that they understand, an investigation hearing, so that they understand what's being put to them and they're able to communicate properly. And in respect to communication, another time it may be appropriate to allow somebody to be accompanied is if perhaps the employee being investigated, if that employee or worker's language isn't English, if their first language isn't English, it's clearly useful to have somebody there to perhaps explain and interpret for them. I think certainly when you're doing the interview, what you need to remember is you're gathering evidence, not making a decision. You should only be recommending where there's a case to answer. I personally wouldn't, and I've seen investigation reports that actually not only recommend disciplinary action, but have recommended a level of sanction. I wouldn't do that. I think your purpose as an investigator is to get all of the evidence you can and produce a balanced report, and you should only be recommending whether there's a case to answer and whether it should be progressed to a disciplinary hearing, not what sanction may be appropriate. Look at the next slide, looking at common mistakes. Not gathering evidence quickly enough is a mistake that's not often made, but it does happen. Things like CCTV, you've got to remember, will usually be on a cycle where they're erased after 30 days. If you leave it too long before you start interviewing witnesses, recollections become vague. One example that I experienced of this, it was a tribunal hearing. I got it 2 days before it was due to start. It was involved in an assault case. The assault had been, the employee had been suspended, but the assault had been referred to the police. And for some reason, the police or the employer contacted the police and didn't do any further investigation on the basis that the police were going to disclose their investigation into the alleged assault. The police investigation went on for 9 months. And at the end of the 9 months, the police wouldn't release any of their notes from the investigation interviews. The employee was therefore left with trying to interview people and ask them to remember something that happened 9 months previously. As you can appreciate, probably sometimes a difficult task. As it happened in that particular case, such was the incident, and the recollections of the witnesses were quite vague and were quite helpful. But there is a risk, there was certainly a risk in that case of people having left the organisation. What do you do then? How do you investigate those? So, like I say, one of the common mistakes is not gathering evidence quickly enough. You need to act quite quickly in investigating a matter. Relying on evidence from one source is another mistake. Sometimes there may only be evidence from one source, and it might be quite compelling, especially if that evidence is documentary evidence. But it's evidence from perhaps a witness statement, and it's only one person. It may not be that compelling or reliable. Watch out for avoidable delays. Always keep the employee informed of any delay and the reason for the delay. Perhaps if you can't interview someone else, if you've interviewed an employee who's under investigation and you're having to do further investigatory interviews, if there's absences or holidays and you're not able to progress it, keep it. Certainly if it's a longer period. I think employment tribunals are not bothered about a week, perhaps a couple of weeks. Once it starts getting beyond that, then clearly you need to be keeping the employee, especially if they're suspended, appraised of the progress of the investigation. Touched on police investigations. Unless instructed, my advice would be, unless you're instructed, if the police are involved, theft, assault, unless you're instructed by the police not to investigate, my advice would proceed with the investigation. Don't delay. Not keeping clear and comprehensive records it is a genuine problem. You need to make sure that all interviews are documented and dated, preferably with the times and breaks of any interviews also recorded. Keep a detailed record of exactly what was said and who said what. Don't summarise it. That becomes quite difficult when it's summarised, to establish who said what in response to what question. And one of the things you find with disciplinary hearings, certainly that I find when I'm looking at the paperwork when it all comes to me, if there's a tribunal, is that what's been said in a disciplinary hearing might be different to what's being said at the initial investigatory hearing. So you need to be quite accurate in recording who said what and in response to what. So if there's any discrepancies between an investigatory hearing and a disciplinary hearing, it's there for all to see. Again, not keeping a balanced view. As an investigator, like I say, it's just you're looking to gather information and establish facts. So you need to make sure anything you do is quite balanced and neutral, especially if you're compiling a written investigation report at the end. Knee-jerk suspensions should be avoided. Consider, again, based on the grounds that we've touched on, whether suspension is appropriate, because clearly where a suspension isn't reasonable or unnecessary, it could potentially be grounds for constructive dismissal. Finally, let's look at some red flags or matters which may come to your attention during the course of an investigation, which may affect the outcome of that investigation. For example, does someone have a protected characteristic as defined within the Equality Act, which may mean that they're less able to adhere to the standards of behaviour or performance that you would expect. I'm thinking particularly of a disability. If the employee has a disability, or you suspect they may have, has this had a potential impact on their conduct or performance? If that's the case, it may be appropriate at that point to stop the investigation and get further information, perhaps in the form of a medical report from a GP, consultant, or occupational health. What if the individual's experience particularly challenging circumstances outside of work? May not tell you about that. You may not be aware of it. It's something that you should probe in the investigation, because clearly it could have an impact on the behavioural performance. It may not do, but as an investigator, that's something you want to be putting before someone who's hearing a disciplinary hearing, so that they're in possession of all the facts. Is the team culture such that the individual may not have realised that the behaviour was unacceptable? Quite often you come across breaches of procedure, perhaps taking and consuming goods without paying for them. You start an investigation, and you find that actually it's quite a widespread practice, and the person who is being investigated wasn't aware that that behavioural conduct was unacceptable. That's just been a bit of a quick canter through the investigation process. I hope it's been of some use. I think Kate's probably going to look at taking some questions now. And on that note, I'll hand you back to Kate.
I am. Thank you very much, Gary. One question that's come through while you were talking was about interviewing people. Given the situation at the moment with the COVID-19 pandemic, is it appropriate, Gary, to interview people online or via video call or by the phone potentially, rather than having to meet face to face?
Yeah, I think it is. Certainly, I'm advised on disciplinary and grievance hearings being done by a process. I can't see why an investigatory process can't be done in that way too. Yeah, again, as long as you're ensuring that confidentiality is being maintained. Yeah, I can't see any reason why you can't do an investigator hearing remotely. I mean, like I said, the actual ACAS Code of Practice doesn't talk about investigatory hearings, so it's not always necessary to have one. What you must do is conduct an investigation. How you do that is entirely up to you. So there's nothing to say that you can't do it in a different way than you would ordinarily do it.
Great, thank you. Suspension, we've talked about suspension quite a bit, Gary, but I think it's fair to say, isn't it, that employment tribunals will always sort of err on the side of not suspending employees if that's at all possible. Would you agree with that?
Yeah, I mean, it's sort of late, there's sort of been a little bit of a focus on suspensions. I think what you've got to remember is that if somebody's suspended, it may be quite difficult for them to come back. Really, again, you should suspend only if necessary. If it's an offence of gross misconduct, it may be appropriate, but we touched on 3 grounds there. One is where that you're concerned that for the safety of other employees or the business, or that there might be damage to the business. If it's theft, if you think somebody's stealing, you don't want to leave those people on the premises. If you think that there may be any threat physical to other employees, that's a reason. Or if you think that evidence may be tampered with or destroyed, suspension may be appropriate. And like I said, Kate, you should keep it under review. I've certainly dealt with one recently whereby the initial allegation was potentially one of gross misconduct, but as the investigation progressed, that was reduced to one of misconduct, because it was more like a breach of procedure than gross misconduct, and the employer quite rightly at that point asked the employee to come back into work and lifted the suspension.
That's great, thanks, Gary. And in a grievance situation, so you touched on grievance situations where it might be appropriate to transfer one of the employees to a different area. How would you go about doing that? Obviously, it can be quite sensitive, can't it, grievance situations?
Yeah, I mean, I think you try and do it by agreement. I think my approach would always be to ask the injured party if they're prepared to either relocate, transfer someone else. The person who the allegations are about, or maybe the subject of the allegation, perhaps if it's bullying or something like that, may be a little bit reluctant to move on the basis that actually, well, nothing's been established or nothing's been proven that the allegations of any foundation. Clearly, if there's quite a lot of people making the allegations, then it may be appropriate at that point to suspend the person who the allegations are about. But if it's just one-on-one, I think my concern would be leaving the person who's raising the grievance in the same position whilst the investigation and the grievance process is ongoing. Because if it's bullying, they're still essentially in the same position until that process is concluded. So I would be looking to agree with them to either get them to move to a different location or even just remove the line management duties from the person who's the alleged perpetrator.
Great, thanks, Gary. And we've talked about suspension, but we haven't mentioned pay. So I think we ought to make it clear to everybody that if you are suspending somebody at this point, it would always be with pay.
Yes, it should be with pay.
You should never suspend without pay at this point. There's been a couple of questions that have come through, which is great. Kate has asked, are we obliged to attempt to make contact with ex-colleagues or third-party witnesses if they've been mentioned as key witnesses in an investigation?
Interesting one. Yeah, I would always recommend trying to do it. Just perhaps if we've got a contact number or an address or an email, again, emphasize that it's confidential, but I always think that it's helpful, even if they say, no, I don't want to participate, if you end up sat in court, that you've got some evidence to say we have tried to use that, we've tried to gather some evidence from that person. You know, we were advised that they may have something relevant to contribute, and we've tried. It certainly means that you're less open to criticism if somebody says, well, they may have been able to provide perhaps a silver bullet and you didn't ask the question. I think if you at least try, then I would suggest that should always be something you look at. Yeah, definitely.
And Gary, in terms of gathering evidence, how about personal information? For example, personal social media accounts. This comes up quite a lot, doesn't it? If an employee has posted things on their personal social media account outside of their working time, is it appropriate for an employer to take that into account during an investigation?
I think the answer is it can be, yeah. I mean, although it's posted on as personal, it depends on how personal it is. You know, where information is posted or on a personal account, but then gets into the public domain, then clearly it may be relevant. You know, if it's brought to the employee's attention, especially if the employee is identified, there's something within that post that might be damaging to the employer's reputation, or the employee's making derogatory comments about the employer. You know, it may be that the employee doesn't specifically identify the employer, but it's quite clear from everything else that that employee is employed by that particular employer, and the comments they're making is about the employer. I think that you've got to be careful about actually delving into people's private social media accounts. There's a line, I think, there where a tribunal may say, what right had you to go into that? But if that information gets into the public domain, even if it was meant to be private originally, then I think the employee is entitled to investigate that. So if you've got an employee who brings a social media post to you from another employee, you're entitled to investigate that.
Thank you. And Heidi's asking about emails, Gary. So is it good business practice for department managers, or any managers, I'm sure, to be able to view team members' work emails? Or because of data protection, is that not appropriate?
I think as long as you've got a policy that says that they may be viewed, that's fine, and you have a reason for viewing them. But you need to be quite transparent in your policy that you may view emails sent from work accounts. You need a good reason for doing it. You wouldn't just do it as a matter of course.
And investigation meeting notes. Kate's asking whether any weight is given to whether or not these are signed. Does it matter?
I think it's helpful, but clearly people being investigated are probably under a little bit of pressure. It's not a comfortable experience, I can't imagine. And I suspect there's always some sort of chance that they're going to come back and say, well, you know, there's a dozen pages there. I didn't read each one individually. I felt under pressure to sign them. It wasn't a great experience at that time, and I just signed them. I think it's helpful to have them signed, I think is my answer. But, you know, if somebody starts challenging it, you know, there is a possibility that they could persuade a tribunal that actually, well, I signed them, I didn't really read them. It was during the course of a disciplinary or an investigation hearing. But yeah, I think my answer would be, if you can get them to sign them and agree to them, that's definitely advantageous.
And of course, it's important to share those notes as well with the employee in question.
Yeah, one of the things I was going to say, don't always, perhaps should have mentioned it in the webinar, don't always give any assurance of confidentiality. I mean, confidentiality in terms of you telling that the employee being interviewed, that interview must remain confidential, but I wouldn't personally give anyone any assurances that whatever information they provide in that interview will remain confidential.
Michelle's saying, Gary, that she works for a charity, works with many volunteers. Would the same process be used with volunteers as we do with staff?
Yes. I mean, in terms of gathering information, it would be. Clearly, in terms of whether a disciplinary procedure applies is a different matter, because they're probably, it depends whether classed as workers or employees. But certainly, if, for example, you were investigating an employee or the conduct of an employee, and a volunteer had evidence that you think may be helpful, then yes, you can ask that volunteer to participate in an investigation process.
Great, thank you, Gary. Are there any circumstances where you don't think it's necessary to conduct an investigation?
I think the short answer to that is not really. There is a case, it's a sort of well-established case, called McDonald and Boys and Girls Welfare Society, and that was to do with it was a care home, and I think one of the employees had allegedly spat and hit at one of the residents, one of the boys in the care home. He admitted that he'd sort of he said he'd slapped the boy, but not deliberately. I think he said he'd spat in the direction of the boy. Essentially, what had happened was he'd admitted to the conduct, but not the same level of conduct. And the tribunal said, and the relevance of that case, the reason I'm raising it is what the tribunal said, is where there is gross misconduct and where the employee admits it, then there's less of a need for the employer to show that they conducted this reasonably sufficient investigation. There's quite a bit of onus, as you probably gathered going through that webinar, on the employer in establishing reasonable grounds to hold the belief they did, and the only way they can have those reasonable grounds is to conduct a sufficient an investigation as is possible. And what that case said was, where there is gross misconduct involved and where the employee to an extent admits it, then there is that less of an onus on the employer to do the investigation. But certainly you do need to start an investigation and you do need to establish at least some basic facts, even if that applies. But my advice is, I mean, these are cases, these are extreme cases that get to courts like the Court of Appeal. So, you know, they're out of the ordinary. Ordinarily, my advice would be you generally need to do an investigation.
Thank you, Gary. Lee's asking, at what point do you disclose witness statements or facts during an investigation? Do you disclose them before, or do you just use them as questioning during a disciplinary?
Are you talking about well, if it's, there's a couple of cases where there is no requirement. I'll look at a couple of scenarios here. There's no requirement to provide any prior notice of an investigator hearing to anyone. But there are a few cases where they're saying, well, you need to be careful that you don't ambush someone. It depends. Ordinarily, you may not want to give people notice of an investigatory hearing. They may get rid of evidence before you conduct that. So you can ask somebody to come in to an investigation hearing. The reason I raise that is the cases where they've gone wrong, where courts have said, well, you've ambushed someone, is where there's been quite a bit of evidence that the employers had before they've spoken to the employee under suspicion. But when they've got them into that investigation hearing, they've not sort of given them enough of an indication of the evidence that they have. and what they're being asked to provide information about. They've been ambushed to an extent. If we're talking about, so I would suggest in an investigation hearing, you don't need to be telling the employee or providing evidence to the employee to answer or provide any information about whatever you're investigating. But you do need to give them enough investigation to know, enough information, I should say, to know what it's about. When you get to the disciplinary hearing, you do need to provide all evidence that you're relying on in sufficient detail to allow the employee to know what the allegations are and be able to answer them. And that will be actually by producing physical evidence, be it witness statements, be it copies of documentation, be it images of CCTV, and you should produce all that evidence prior to the disciplinary hearing taking place. It's quite useful to make sure it goes out with the disciplinary invitation, and it's quite useful to actually refer in the disciplinary invitation to what evidence is being provided, so that if it's ever challenged, you've got evidence of what was sent to the employee. But at that point, it's at the disciplinary hearing point that you really need to provide that physical evidence and supporting the allegations. And like I said, it's not just evidence supporting the allegations. Because you're looking for a balanced view as an investigator, you need to provide evidence that may in fact not support the allegations, if there is any.
Thinking about smaller organisations, Gary, you did touch on it before, that obviously ACAS Code of Practice suggests that it's better if a different person conducts the investigation and conducts the disciplinary. In smaller organisations where that might not be appropriate, at what point do you think it's okay for the same person or the same people to do those two roles?
It would need to be a very, very small organisation. If there's any way of separating those parts of the procedure, the investigation, the disciplinary and the appeal hearing, it must be done. Even if you've got perhaps 3 directors or 3 managers, really that's sufficient for an employment tribunal, I think, to say, well, one could have done the investigation, one could have done the disciplinary, and one could have done the appeal hearing. You would really need to show that there was a genuine reason as to why that couldn't happen. You know, if you didn't have sufficient management or level of employee to do that, or perhaps people were off. If you did have sufficient numbers, but they just weren't available. But generally, you know, they will expect that separation of the processes. One of the times when it may be appropriate for the same person to do that, and again, we touched on it in the webinar, one of the times it will be appropriate for the same person to do the investigation and the meeting, which may result in a warning, will be where it's related to performance, because the person doing the meeting that may result in the warning will generally be the person's manager, who will generally be the person who will be aware of the poor performance and will have provided evidence of that poor performance as part of the investigation. So that's one time when it might be the same person. But certainly, were the conduct, you would need to be a very, very small organisation, and you would need to show as to why it actually wasn't possible to do it.
And Lee asks, during investigation interviews, do you need to have witnesses, or can it just be one person interviewing the employee in question?
It can be one person. It can be one person. There's no reason for it to be 2 people, other than if it is helpful for someone else to take notes if you're asking the questions, because clearly, like I said, one of the things, one of the common mistakes is not recording absolutely accurately what's been said and what's been said by him. So it's not necessary to have someone else there. If you feel more comfortable to have someone else, then get someone else there and get them to take the notes. But there's no requirement to have someone there. If you're in any way concerned that some of the questions may be disputed or some of the answers, then yeah, like I say, get someone there.
Thanks, Gary. Well, we've got just a couple of minutes left, so if anybody's got any other questions, please do send them through now. Otherwise, I think we'll draw this webinar to a close. I hope that you've all found that really useful. Thank you for joining us today, and I hope that we've given you a bit of a better understanding of investigations and why they're important. please remember that if you are a member of Co-ops UK and you have either our contact or our HR package, you can always get in contact with us at any point to ask for more specific advice regarding your co-op if you are finding yourselves needing to conduct an investigation, or if you get into one and you sort of think, actually, there's some sticky issues here that I'd like to talk through with somebody. If you're not a member, there'll be more information on our follow-up email explaining how you can look into those packages and what they are. We're really interested in understanding from you whether the training courses and the webinars that we're providing are useful and they're the things that you'd like to hear. I'm just going to run a really quick poll, if that's all right, now to ask you whether or not you'd be interested in a more in-depth webinar on this topic. So I'll start that now, but equally we're also really keen to hear whether there are any other topics that you'd like us to talk about. So please do let us know. Always get in touch with us. We're always really keen to hear from you. Thank you ever so much for joining us today, everybody, and enjoy the rest of your day.